Hello everybody, welcome back to our CMA classes. So let's resume our law class and let's complete the remaining section of this chapter, compromise, arrangement and amalgamation. Okay, so the first section of today's class is going to be section 233, which is of merger or amalgamation of certain company. Okay, under this section they are saying that there are some certain companies, okay, which can be go for amalgamation or merger. Okay, and they are: number first, the small company; number second, where one of the company should be the holding company and the other should be the wholly owned subsidiary company. Okay, the third is about the prescribed class. Okay, so let's read out what I have written, okay, as per law. So a scheme of merger or amalgamation between two or more companies only if they are either small companies, okay, or one company among them should be holding company and the other company should be wholly owned subsidiary company, okay, or such class or classes of company as may be prescribed. Okay, so for these three company, the law is saying that these three company can go for merger and amalgamation. Okay, but there are some prescribed thing which is to be done by this company. Okay, first of all they have to issue a notice. Okay, issue a notice to whom and by whom? By the transferor company and the transferee company. Okay, the issue notice should be issued by the transferor company and the transferee company to whom? First of all, registrar and to the liquidators, official liquidator. Okay, but for what reason? Okay, the registrar and official liquidator can give suggestion, okay, or oppose to the merger and amalgamation of prescribed companies. Okay, so let's read out: issue of notice, objection or suggestion. Okay, notice is to be issued by transferor company. Is it clear? Yes. And transferee company, and to whom? To the registrar and the official liquidator. Okay, now this objection and suggestion is to be given within the 30 days of from issue of notice. Okay, so the registrar and official liquidator can object, okay, or give some suggestion within 30 days. Okay, and this objection or suggestion shall be considered by the company, okay, in the general meeting, and that is to be okay, the merger and amalgamation, okay, which the notice was issued, okay, that should be approval by whom? By the member or class of member in general meeting. Okay, and the scheme would be approved only if the members and class of member holding at least 90% of total number of shares vote in favor. Let me say it again. First of all, these are the company which can go for merger and amalgamation. This section says 233 says that there are some company which can go for merger and amalgamation. Number for small company, number second holding, one of the company should be holding, second was the wholly subsidiary company, okay, wholly owned subsidiary company, okay, or the third prescribed company. Okay, and before doing that they have to go for the issue of notice should be done. Okay, issue of notice by transfer company and the transferee company to whom? To the registrar and to the official liquidator. Okay, they can give the suggestion or can object. Okay, and that objection and suggestion is to be done within 30 days, and that objection and suggestion is to be again considered by the company in the general meeting. Okay, hope so till it was clear. Now the company is saying that the scheme would be only approved if the member or class of member are holding, okay, at least 90% of total number of shares vote in favor. Okay, those who have given the favorable vote. Okay, when it is going to be approved by member or class of member in the general meeting. Okay, and these approved member should have at least 90% of total number of share vote of favor. Okay, hope so till this everything was cleared. Now the company have to file the solvency declaration to the registrar, the company involved in the merger. Okay, now the approval of creditor is to be taken. Scheme is to be approved by the majority representing 9/10 in value of creditor or class of creditor. Okay, filing of approval scheme is to be is to be filed by the transferor company, and this file of copy is to be approved, and this is to be filed to whom? The approved scheme is to be filed to whom? First of all, the central government, second the registrar, and third the official liquidator. Once the approval of scheme is done, okay, the company have to send the copy, okay, approved scheme, copy of this approval scheme, okay, is to be sent to the registrar, first of all, the central government, registrar, and official liquidator. Okay, hope so this was clear. But what I said earlier, but we have to give the notice, issue the notice to registrar and official liquidator, okay, and they can give or oppose, give suggestion within 30 days. But what if they haven't given any suggestion or not oppose the notice of approval of that scheme? In that case, the CG shall register the same. Okay, what if no objection or suggestion is made by whom? The official liquidator or the registrar, right? In that case, the central government shall consider the same. The scheme shall be deemed to have the effect of dissolution of the transferor company without giving the process of winding up. Okay, so let's go for this other section, which is of 234, merger and amalgamation of company with the foreign company. Before going with merger and amalgamation with the foreign company, the company have to take the prior approval of RBI. Okay, let's read out. Section 234 is going to be applicable for those company who are registered under this act, okay, or the company who is incorporated in jurisdiction of such country notified by the CG. Either those company which are actually registered under this act, or the company who are incorporated, okay, in the jurisdiction of such countries notified by the central government. Okay, only those company would be eligible to do the merger and amalgamation with the foreign company. Okay, now the prior approval have to be taken by RBI. Merger of foreign company into the company registered under this act, okay, merger of a company registered under this act into a foreign company, these have to be taken the approval of RBI. Hope so this point was also clear to you. Okay, let's go out and check that. There are some terms and conditions of such merger in case of foreign company with foreign company, okay, which says the payment of consideration, okay, payment of consideration to the shareholder of merging company as per scheme drawn up for such purpose, and such payment to be made either in cash, okay, either in some depository receipt, or partially in cash or partially in depository receipt. Okay, hope so this point was also clear. Now we are going for the other section, which says the section 235 of power to acquire shares of shareholder is dissenting from the scheme of contract approval by the majority. Again, let me say it, power to acquire share of the shareholder, which means dissenting shareholder. Okay, now what is dissenting shareholder? First of all, those shareholder who have refused to give their shares, okay, who are not agreeing with the approval of merger and amalgamation, so they have refused to give their share, is dissenting shareholder. Okay, now let us read it again. Power to acquire share of dissenting shareholder, right, from the scheme of approval contract approved by the majority. Section 235 says the transferee company may prepare a scheme or a contract, okay, it is to be given to whom? To the transferor company, okay. Transferee company will prepare the scheme or the contract for the transferor company. Okay, for what purpose? First of all, this offer is made to the shareholder of another company, okay, to acquire their share. Okay, the dissenting shareholder, those shareholder who have not given their shares to the transferee company, okay, to the transferee company, in that case transferee company may go for this scheme. Okay, in that, what is the main purpose? To acquire the remaining share from the transferor company. Okay, is it clear? And now this process, the process involved in this case is called takeover. Okay, the process is going to be known as takeover. Okay, so the offer shall remain open for the period of 4 months. Is it clear? Now any shareholder of transferor company may agree to transfer share to the transferee company. Okay, basically this section says 235 says to acquire the shares from the dissenting shareholder, okay, or transferor company by the transferee company. So first of all, either they what are they going to do? The transferee company is going to prepare a scheme or contract, okay, for transferor company, okay, and this process is known as takeover, okay. But the main purpose is to acquire that remaining share from the shareholder, dissenting shareholder or transferor company, okay. And this is going to be remain open for 4 months, okay, remain open for the 4 month. Hope so till this it was cleared, okay. Now the approval of the offer. The offer made by transfer company, first of all, transfer company is approved by the shareholder holding not less than 9 in value of share, okay. The transferor company may give notice to the dissenting shareholder that it designed to acquire his share. The notice by the transfer company is to be given to dissenting shareholder within 2 months from the expiry of period of 4 months, okay. The notice of to the dissenting shareholder is to be given within 2 months from the expiry of that 4 month, okay. And let's go for some note which I have written. Dissenting shareholder means a shareholder who has not assented to the scheme or contract, or who has failed or refused to transfer his share to the transferee company, okay. There is some right of dissenting shareholder. First of all, dissenting shareholder can go for tribunal, okay. They can make an application to the tribunal that the acquisition of share shall not be permitted. They can definitely go for tribunal that the share shall not be permitted, and they can write the reason, okay. Acquisition of share by the transferee company. No application is made by dissenting shareholder to the tribunal within 1 month of receipt of notice of acquisition. First of all, in some specified case, okay, the transferor company dissenting shareholder are having a right, they can go for the appeal to tribunal, okay, that this share shall not be, the transfer of our share shall not be permitted, okay. But what if the dissenting shareholder have not given, have not applied for application to the tribunal within 1 month, of receipt of notice of acquisition? In that case, the acquisition of share by the acquisition of share is going to be taken by the transferee company, okay. If the dissenting shareholder have not taken any right, in that case it is going to be approval by whom? The transferee company. The shares are going to be approved by, acquired by the transferee company. Hope so this was clear, okay. Now with the application is made by dissenting shareholder, but such application is dismissed by the tribunal, okay. There are 2 cases. First was if the dissenting shareholder have not taken any right, okay, have not applied for application to tribunal, okay, within 1 month from the receipt of notice of acquisition, okay, or the tribunal, or they have given the application to the tribunal, okay, that the share should not be permitted to the transferee company of dissenting shareholders, right. In that case, if the tribunal have dismissed their application, in that case also what is going to happen? The acquisition of share by transferee company is going to happen. Hope so this part was also clear, okay. The transferor company shall not entitled to acquire the shareholders of dissenting shareholder if tribunal allows application of dissent shareholder. But what if the tribunal itself say that the share should not be taken or acquired by the transferee company? In that case, the acquisition is not going to happen, okay. Let's check the next section, which says the purchase of minority shareholding. Section 236 says the purchase of minority shareholding. Minority shareholder shall notify the company of their intention to buy the remaining equity, okay, equity share. So here what is going to happen? The majority shareholder will make an offer, okay, make an offer to buy the equity share, of the minority shareholders, okay. But that price is to be determined by the valuation by registrar, okay. Let's check what I have written. the majority shareholder make an offer to whom? To the minority shareholder, ठीक है, to buy their equity shares, okay, to buy their equity shares. Hope so this was clear. And that share is to be determined on the basis of valuation by registered valuer, ठीक है. So that share is to be valued on the basis of registrar valuer, okay, according with the prescribed value. Hope so this part was clear. So in this section 236 is about the purchase of minority shareholder, ठीक है, of equity shares by the majority. Okay, so they make an offer to buy the minority shares, okay, equity shares of minority shareholding, ठीक है. For that they are going to take the value of valuer, which value? The registrar valuer, ठीक है, as per the prescribed rules. Let's check out the other points of this section. Say the deposit of money by the majority shareholder. The majority shareholder in this case have to deposit the amount equal to the value of share of the minority shareholders, ठीक है, in the separate bank account, and that bank is to be operated by the company whose shares are being transferred for at least 1 year. Okay, so that bank in which the majority shareholder have to deposit the amount equal to the value of share of minority shareholders, ठीक है, in a separate bank account, and that bank account should be operated by the company. Okay, hope so this point also cleared. Amount deposit shall be disbursed to entitled shareholding within 60 days. Okay, let's go and check out the remaining condition of this section, which says the situation where minority shareholder fails to deliver the share. What happens if the minority shareholder fails to deliver the share? In that case, any minority fails to make physical delivery of share within the time specified by the company which shares are being transferred, the share certification shall deem to be cancelled. So the share certification is going to be cancelled, okay, or the company who are being transferred shall be authorized to issue share of cancelled share and complete the transfer. In that case, the company, okay, will authorize to issue the cancelled share and to complete the procedure of transferring the share according to the law. Okay, where second condition says that situation where the shareholder has died or ceased to be exist. In that case, any shareholder who has died or ceased to exist or hire successor, administrator, assignee have not been bought or recorded by the transmission. In that case, the right of such shareholder to sell his shareholding shall continue for the period of 3 years from the date of acquisition of majority shareholding. In that case, what is going to happen? The right to sell the shareholding, it's going to be extended by 3 more years, ठीक है, 3 years from the date of acquisition, of that majority shareholding. Okay, third condition says situation where shareholder holding 75% more shareholding reach an understanding for the transfer at the higher price, where the shareholder get the excess amount of shares. Okay, in that case, the major shareholding share that in this case, what is going to be happen? The additional compensation received by the shareholder is to be distributed to the minority shareholders, right, in the pro rata basis. Okay, let's read out. The majority shareholder shall share the additional compensation to receive by them with such minority shareholder on the basis of pro rata basis. Okay, hope so this was also clear. Let's go for the last condition of this section, which says the situation where majority shareholder fails to acquire the full purchase of shares of his minority shareholders. This is the case where the majority shareholder actually fails to acquire the full purchase of share of its minority shareholders. Okay? Then the provision of this section shall continue to apply the residual minority shareholder even though the share of the company of the residual minority equity shareholder has been delisted. Okay, the period of 1 year or the period specified in the regulation made by Security Exchange Board has elapsed. In that case, what is going to happen? The minority shareholder, they have to continue. Okay, whether they have not given the shares. Okay, when the some condition, what happens? The majority shareholder fails to acquire the minority shareholder shares. ठीक है, So in this case, the share of company of residual minority equity has to be listed, has been listed, even though the company is going to continue to apply residual minority shareholding. ठीक है? In both the cases, when the residual minority equity shareholder has been delisted, whether they have delisted or the period of 1 year of the period specified in the regulation has made by Exchange Board of India has been actually elapsed. ठीक है? In both the condition, this condition is going to apply. ठीक है? Apply in what case? The residual minority shareholder is going to be, ठीक है, apply, continue. Okay, so they were the 4 conditions in this section stating that what is going to happen if minority shareholder fails to do so. Okay, or the majority shareholder were unable to acquire the full shares. ठीक है? And if the minority shareholder died, okay, the shareholders died or ceased to die, ठीक है, or the majority shareholder gets more than the actual value of shares. Okay, so there are 4 conditions which we have to think and give the answer as per the situations. Okay, so let's go for this section 237 of power of central government to provide for amalgamation of the company. ठीक है? In this case, what is going to happen? The central government have power, ठीक है, empower to amalgamation, to make the amalgamation of 2 or more company. ठीक है? But for what? But in favor of public interest, in favor of public interest. In that case only the central government take action. Okay, let's go and check out what I have written. The central government may empower to order amalgamation of 2 or more companies. Okay, 2 or more company to the single company. Okay, with 2 or more companies are amalgamating. ठीक है, amalgamating. Okay, 2 or more company are amalgamating to single company. Okay, and that is going to happen only if the CG is satisfied by such amalgamation essential in the public interest, and that is to be issued by notification in official gazette. Okay, let's go for the other condition written in the section. The condition for making an order of amalgamation, the CG shall not make an order of amalgamation unless the copy of proposed order is to be sent by whom? Sent by the order of amalgamation. It has been sent in draft to each of the companies concerned. So the draft order, it is to be sent to whom? Draft order is to be sent to the transferee company. Okay, the time for preferring an appeal to the tribunal has expired. In that case, the CG will not make an amalgamation. ठीक है, there are some condition which saying that CG will not go for the amalgamation. First of all, if the copy of draft is not sent to the amalgamation is not sent to the transferor company and transferee company. ठीक है. Second, the tribunal, the appeal of the time for preferring the appeal for tribunal have been expired. ठीक है, the appeal has been disposed of by this. This point is related to the second point of tribunal. ठीक है, whether appeal has been disposed of by the tribunal. Appeal was actually disposed of by the tribunal. ठीक है, in that case also the CG will not go for amalgamation. ठीक है. Third says the central government send draft copy which is proposed amalgamation to each of the company. Okay, the central government will send again the draft copy to whom? The proposed amalgamation to both of the companies. Okay, the shareholders, creditor of each the company can give objection and suggestion, but within 2 months. ठीक है, within 2 months. The CG may modify the draft order when it may deem fit. Okay, now there are some conditions which say that there is going to be the same right, same interest of the creditors and members of transferee company. Okay, the transferee companies member and creditors, ठीक है, will have the same right, same interest, same right to the transferor company, the right which was given to the member, the right which was given to the creditors, ठीक है, as per their interest and right would be same of to the transferee company. Okay, so let's read out. Every member creditor of each of the transferee company before amalgamation shall have the same interest right against the transferor company as he had interest and right in the transferred company. Okay, let's go for the second condition. Second thing says the transferee company, ठीक है, if the transferee company's member and creditor, ठीक है, have less than his interest right against the transferor company. Okay, let me say it again. What if the amalgamation have taken place? Okay, the transferor companies, ठीक है, the right given to the transferor company member and the creditor is not actually or is less than the it's when it's compared to two of the company, it's actually less. ठीक है, the interest of the members and interest of the creditor is less in transferee company. In that case, what is going to happen? The members and the creditor will entitle for compensation. Okay, so here I have written the transferee company have less than his interest right against the transferor company. In that case, the member and the creditor will entitle for the compensation. Hope so this point was also clear. So let me read it. In case of interest or right of the member or creditor against the transferee company or less than his interest or right against the transferor company, okay, then he shall be entitled to receive, who, the creditor, the member will entitled to receive the compensation from the company. The compensation, now who is going to decide this compensation? This compensation is to be, shall be assessed by the authority, and this compensation is to be published in the official gazette of the creditors and the members. ठीक है, now last point says any person agreed by any assessment of the compensation made by prescribed authority may within period of 30 days from the date of publication of such assessment in official gazette prefer to appeal to the tribunal. Okay, but what if they are not satisfied? In that case, they can go for the appeal to the tribunal within 30 days. Okay, the last thing, the copy of every order of amalgamation is to be made and it is to be laid before the two houses, each of the houses of the parliament. Hope so this point was also clear. Okay, let's go for the next section, which says the registration of offer of scheme involving transfer of share. There are simple things which is written in the section, so let me read out. A setter director of transfer company shall prepare a circulation. Okay, so in this case, first of all, the transferor company director have to prepare the circulation. Okay, and that circulation shall be addressed to member of the transferor company. The circulation shall disclose the offer made by transferee company to the member of transfer company for acquisition of their shares. Second point says every such offer shall contain a statement by transferee company of disclosing the step. Okay, so they have to disclose the step. Okay, it has taken to ensure the necessary cash will be available first of all. Okay, third point says the circular shall be presented to the registrar for the registration. So it is to be presented to the registrar. Hope so till this was clear. First of all, the transfer company director have to make the circulation. Okay, in that they have to disclose everything. Okay, and that circulation is to be what the disclosure is to be made. Yes, and that is to be presented to whom? To the registrar for the registration. Hope so till this it was clear. Okay, fourth point is the registrar may refuse for the reason, okay, to record in writing to register the circular. In such circular, if the registrar may refuse, okay, but in some condition, that if does not contain the prescribed information, if the information is inadequate, okay, in the circulation, okay, the information is inadequate, okay, or the contain information in manner which is likely to false impression, likely to give the false impression. In that case, the registrar can cancel the circulation. Okay, fifth point says in case of registrar refuse to circular the, what if the registrar have refuse to register the circular, in that case he shall communicate such refusal to both of the parties within 30 days of application. Okay, in that case they have to communicate okay, within 30 days of refusal. Okay, the next point is going to be say the application, 30 days of application. Okay, next point says the company shall appeal to the tribunal against the order of registrar refusing to register any circulation. The company have the, they can go for appeal to the tribunal. Okay, they have one opportunity, they can go for appeal to the tribunal. Okay, next, the last thing says if any circular issued before it is to be presented to register for registration and is registered by the, actually what happened in this point which says what happened, the circulation is actually not presented to the registrar. What if, okay, and the circulation is actually circulated and it's not presented before registrar. In that case, penalty of 1 lakh is going to be imposed on the directors. Okay, on the directors. Okay, so this was section 238, registration of offer of scheme involving transfer of share, which says first of all the director of the transfer company have to make the circulation. In that circulation, this disclosure is to be made. Okay, then it is to be presented to the registrar. What if it is not presented to the registrar? In that case, 1 lakh is going to be imposed, the fine imposed. Okay, to whom? To the director of the company, because he made the circulation. Okay, and he have not presented before the registrar. But what if it is proposed, the presented to the registrar? In that case, if it is accepted by the registrar, then it's going to be published. Okay, but what if the registrar have refusal? Okay, in that case they have to there are 2 points why the registrar is going to not accept that circulation. Okay, in that case either the information is not adequate, okay, or they have given the false impression. Okay, within 30 days of rejection of that circulation, the registrar have to communicate to both the parties. Okay, hope so. And once they get the communication from the registrar, the company can go for appeal to the tribunal. Okay, hope so this point was clear. Let's go for these other section, which is saying the preservation of books and paper of amalgamation company under section 239. What happened, for disposal of book and paper of a company, prior permission of central government is to be taken. Okay, in this case, the preservation of book and paper of amalgamation company is to be done. Okay, section 239 says that before actually disposing the book of accounts and paper of the amalgamated company, the company have to take prior approval from central government. And what is going to happen, the central government will appoint some person, okay, to examine book of accounts. So let's go and check out. Which shall be amalgamated to another company whose share have been acquired by the another company. So the central government will appoint person to examine the books. Okay, the CG may appoint one person to examine the books and paper of the company before granting permission for disposal of books and paper. Okay, for the promotion, the management of the affair of the company, of the transfer company, again for the promotion of the transfer company, for management of affair of the transfer company, for amalgamation of transfer company, for the acquisition of shares, okay. Last section, this is 240, says about the liability of officer in respect of offences committed prior to the merger and amalgamation, okay, which is of section 240. In respect of any offence punishable under this act, all the officers in the default of the transfer company shall continue to liable for an offence committed prior to its merger and amalgamation or acquisition. So all the person will be liable, okay, in this section. So this was the end of this section, this chapter. Okay, so we have completed the compromise, arrangement, amalgamation, and that's it, guys. You have to do the revision, do the writing practice, go for the previous year question papers, okay, and I'll come with more videos. Till then you have to stay tuned, okay, and do the revision as much you can. That's it. This is Soumya Santosh and we'll meet in our next video. Toodles, guys.